I'm Katie Handley, and I work as a hospital staffing surveyor on OHA's hospital staffing team. OHA's hospital staffing team enforces Oregon's hospital staffing laws, including the updates in 2023's HB 2697 and 2025's HB 3294. This video describes the anatomy of the default final order, which is a key legal document in the hospital staffing enforcement process. The enforcement notice is a document that precedes the default final order. When the enforcement notice is served, which is the date it is mailed, it begins a 20-day notice period during which the hospital can request a hearing to challenge a given warning or penalty. If the hospital does not request a hearing to dispute the determination made by the OHA in a hospital staffing investigation, or if the hospital chooses to waive or withdraw its request, then once the 20-day notice period has passed, OHA will proceed with issuing a final order. This final order, issued by default, will incorporate the findings from OHA's investigation and issue a warning or order the hospital to pay civil monetary penalties. There are several sections in a default final order that we will cover in the remaining slides. Findings of fact and conclusion of law, order, invoice, where civil monetary penalties are assessed, certificate of service, and Exhibit A, enforcement notice. The findings of fact and conclusions of law section in OHA's default final orders tend to be short because it incorporates by reference the more extensive findings in the enforcement notice. The purpose of this section is to set out the relevant facts and conclusions, like the facts supporting the violation finding, imposition of penalties, or issuance of a warning. The enforcement notice attached to default final orders as Exhibit A is incorporated into this section. As such, it is important to review it as part of the facts finding made in this section. The primary purpose of the default final order is to issue one or more orders resulting from violation findings. The order section explicitly finalizes the warnings and orders the hospital to pay any civil monetary penalties. Default final orders may be appealed to the Oregon Court of Appeals within 60 days of the date of a given order. OHA attaches invoices to default final orders listing the case number associated with the violations addressed therein that result in civil monetary penalties. The violations, again only those resulting in monetary penalties, are further itemized by date, statutory citation, and the overall count, including other investigations, of violations for the same statutory provision, as well as the amount due. The amount due shown in each invoice is itemized, and it is limited to the violations resulting in monetary penalties from that particular investigation. It does not reflect the total amount that may be due from that hospital across different investigations. The invoice also contains the payment information. It is important to review that invoice carefully and take reasonable care to ensure payment reaches OHA's hospital staffing team. It is helpful to include the invoice page with the payment. All default final orders will have an attached certificate of service which is signed and dated on the date the order is mailed. A default final order will have its associated enforcement notice, signed and served at least 20 days prior, attached as an exhibit, Exhibit A, for reference. Again, please note that the attached notice of intent to issue warning and/or to assess civil monetary penalties is incorporated and thus is part of the default final order. The findings made in the enforcement notice are also the findings made in the default final order by incorporation. This means that the best way to understand the default final order is to also read the enforcement notice closely and consider them as merged documents. For more questions about hospital staffing requirements and hospital staffing resources such as FAQs, webinars, and hospital staffing shorts, visit the hospital staffing website at www.healthoregon.org/hospital staffing.